In international law there is no Supreme Court. It is up to a nation-state to make its own national decision as to whether to adhere to the judgments of the International Court of Justice or not. Iraq was not a treaty-based member of the International Court of Justice, so that didn't come into it, probably, in our consideration of what we were doing with Iraq. But short of that, it is possible to have a firm legal opinion on the legality of action under the UN Charter for a particular operation. But it is also possible for there to be many different legal opinions as to what is actually legal without having an apex arbiter of what is legal or what is not. What I'm saying is that the United Kingdom's reasons for taking action on Iraq was solely based on UN resolutions. The United States, in its public explanations of policy, throughout this period, suggested from time to time that there were reasons beyond UN resolutions why they wished to deal with the threat posed by Iraq, and regime change increasingly got mentioned as the means by which they would achieve their objectives as far as nulling the threat from Iraq was concerned. The UK, as the prospects for diplomacy declined, were increasingly pulled onto American grounds for going to war, because, if we were going to go to war, the Prime Minister had made a commitment that he would go with the United States. What we were left with the failure of diplomacy to achieve objective, as I have described it to you, was the American set of reasons for going to war with Iraq, not the British ones, and that was something which had to be taken into account by British explanations of policy and by the Prime Minister personally.